Happy 2021. I'm going to talk about a judgment called Fraser and Shropshire Council, which is the first planning judgment to be reported in 2021. And it's a judgment which happily I was successful in. So it's a very long judgment. It's 209 paragraphs long, so it's not for the faint of heart. But what I'm going to do is give you a very quick summary of the facts of the case and some of the points that can be extracted for it. This is hopefully to save anyone who doesn't want to read all 209 paragraphs. So, Shropshire Council, who I was acting for, they granted planning permission for a specialist housing for persons over the age of 55 years. And that grant of planning permission was challenged by some local resident on the basis that it involved direct discrimination against people on the grounds of age, because the development offered less open space than the policy that in Shropshire Council's development plan would normally prescribe. And they said that the justification for it offering less open space was discriminatory towards old people, and that also involved a breach of the public sector equality duty. And they said because if you read the officer report as a whole, it seemed that the reason why there was less open space was because essentially older people don't require as much open space as other people. That was their fundamental contention, which we disputed, but they relied on sections of the officer report to make that claim out. So we were proceeding to the High Court, and about 2-3 weeks before we were actually going to have the hearing in the High Court, the Shropshire Council granted an identical application. The developer had resubmitted their application. It went to the committee again. There was a new officer report, and the council granted that again. And it was the contents of that second officer report which addressed the contents of the original decision and the original legal challenge. And it was the contents of that second officer report which were really important. And interestingly, the court said, well, ultimately, it doesn't really matter whether the first grant of permission was lawful or not, because we've now got a second grant of permission, and it's the contents of that second officer report are what matter. And the court found that when you read the second officer report, there was clearly no discrimination, because the council made it abundantly clear in that second officer report that there was no error of law, and that the decision to offer a less open space was not motivated by any discrimination on the basis of age. So there's a few interesting points. The first is, if there is a legal challenge, how a second application can resolve that, or at least overtake events. The next issue is in respect to inconsistency, because there had been a previous refusal on this site, which led to a redesign, and then it came forward to these permissions that were granted. The local residents said, well, it's effectively the same site, so why are you refusing that and granting this? And the court went with my submission, which was that the scheme had been sufficiently modified such that there was no inconsistency. I should say there were a whole host of points taken against the scheme, which is why there were 209 paragraphs, and there were 5 grounds of legal challenge, but each ground had a number of different points. So it's, for the purpose of this video, I won't go through each and every single point that was raised, but just flag up some of those, the more interesting ones. The other big point that was interesting to take is how direct discrimination and the public sector equality duty were raised, because the court ultimately found that whilst the public sector equality duty was engaged here, there was no breach of it, predominantly because the council had explicitly said this level of open space would have been satisfactory irrespective of the age group identified. And it wasn't motivated by the view that these were for people over the age of 55 years. So that, as a matter of fact, the court found that there was no discrimination, nor had the public sector equality duty been breached. But of course, it's important for any developer that if they find themselves in a situation where they are subject to a judicial review, how a subsequent resubmission, whilst the legal challenge is ongoing, can potentially resolve or at least bolster their case. So if you've got any questions about it, please do get in touch. But anyway, that's the first planning judgment of 2021.